Hi, I'm Roy Delbeck, a customs and trade lawyer with my own firm in Hong Kong, speaking to you from the comfort of my den. And I am honored to be the moderator for today's webinar, which is presented by Global Legal Customs Association, an international network of customs and trade lawyers. The global reach of GLCA in the customs and trade area is unique. Just look at where today's speakers are located. Myself in Hong Kong, Juan Soto and Ricardo Romero from the firm of Chavez Ruiz Zamaripa in Mexico City. Pardon any mispronunciation there. David Stepp from the LA office of Crowell & Mooring. Peter Kirby with his own firm in Montreal, Kirby Law Office. And last but not least, Bert Gievers, who is with the Brussels office of Loyens and Loeff. One will be speaking about the meaning of forced labor, while the other speakers will be providing country updates for their respective jurisdictions, and in the case of Bert, an EU update. The issue of forced labor is clearly one of, or the most top of mind issues in the sourcing area. Every day seems to bring something new somewhere. Before I turn it over to Juan, I will touch on 2 points that cut across forced labor, regardless of the country of importation. The first concerns compliance programs of importers regarding forced labor, specifically who within or outside the importer's company is the architect and monitor of the program. That can make a considerable difference in program efficacy and support. Is it the transportation department of the importer, the logistics department, compliance, merchandising, finance, in-house legal, or outside legal counsel, or some combination of one or more of them? And what is the level of C-suite scrutiny and involvement? One of the most interesting things for me about the new Canadian law that Peter Kirby will be discussing is the requirement, as I understand it, that the annual report to be filed by the covered entity needs to be signed off by the board of the entity regarding the entity's efforts to minimize, reduce forced labor and child labor. Nothing comparable to that in the US that is reports signed off by the board that I'm aware of, at least currently on the federal or state levels. Boy, when the board needs to sign off on something, that really gets a company's attention. The second point I'd like to make is that the speakers are looking at this issue from the point of view of the importing country. Importing countries are not, of course, the only countries who have weighed in or could weigh in on forced labor. China, for example, in 2021, issued an anti-foreign sanctions law to try and stop foreign companies from enforcing sanctions against Chinese companies. That's a subject for another day, as well as the impact of forced labor on suppliers, including suppliers who are blacklisted. But I would be remiss if this was not mentioned. Anyway, I will stop here and turn it over to Juan.
Thank you. Thank you, Roy. Good morning in Americas, good afternoon in Europe, good night in Asia. As an antecedent for this conversation, it is relevant to be aware of how the international regulation, mainly the International Labor Organization, define or the conventions issued by the ILO define the forced labor. And the ILO Convention 29 defines this practice as all work or service which is exacted from a person under the means of a penalty for which said person has not offered him or herself voluntarily. Derived from this definition, the ILO distinguishes three elements for the existence of forced labor. The first one is that obviously a work or service required from an individual. The second is the threat of any penalty. And the third one, and maybe the most important, is that such individuals have not offered him or herself voluntarily to develop this work. In the same sense, the ILO Convention 105, issued in 1957, is aimed to abolish the forced labor. And it is aimed to abolish the forced labor as a punishment for expressing political ideas or political views, for an economic development purposes, for participation in strikes, as a measure of a racial, religious, or other kind of discrimination, as well as a disciplinary measure. A lot of years later, in 2014, the ILO issued a protocol regarding the Forced Labor Convention. This protocol entails some measures to be taken for the prevention of forced or compulsory labor that shall include the undertaking efforts to ensure that the coverage and enforcement of legislation relevant to the prevention of forced labor, including labor law as appropriate, which are applicable to all employees and all sectors of the economy. Also, the labor inspection services and other services responsible for the implementation of the legislation shall be strengthened. In the same year, 2014, the ILO issued a forced labor recommendation, which entails the international cooperation shall be also strengthened between and among members and with relevant international and regional organizations, which shall assist each other and in achieving the effective and sustained suppression of the forced and compulsory labor. In our continent, the United States, Mexico, and Canada Commercial Agreement states in its Chapter 23, which is dedicated to labor matters, that the elimination of all forms of forced or compulsory labor shall be deemed as a labor right. In the same chapter, Article 23.6 states that the parties recognize the objective of eliminating all forms of forced or compulsory labor, including child labor. According to that, each party shall prohibit, through measure it deems appropriate, the importation into its territory of goods from other sources produced in whole or in part by forced or compulsory labor, including child labor. Finally, the same Chapter 23 states that the parties recognize the importance of cooperation as a mechanism for the effective implementation of this chapter, to improve opportunities, to improve labor standards, and to continue advancing common commitments regarding labor matters, including the principles and rights established in the ILO Declaration of Labor Rights, and obviously all the conventions that I mentioned before. That is like a general view of the definition of forced labor, which is, as I mentioned, very, very relevant for the purpose of the following participants.
Thanks, Juan. And before we turn it over to David Stepp for the U.S. update, I just wanted to mention that there will be hopefully some time for Q&A following the last country update or regional update by Bert on the EU. David?
Thanks, Roy, and thanks, Juan, for that background on the forced labor definitions. I'm going to talk today about what's been going on here in the U.S., and it's been incredibly active over the past several years. I'm going to talk about, and I'll go into the next slide here, the forced labor laws. The two main ones that we're dealing with here in the U.S. are Section 1307 of the Tariff Act, which is a worldwide forced labor ban, and the one that is catching a lot of attention these days is the Uyghur Forced Labor Prevention Act, the UFLPA. I'll start with the Section 1307 ban that prohibits the import of goods made wholly or in part with convict forced labor or indentured labor. That was effective since 2016, the beefed up version of that statute, which really changed. It was a sea change with respect to the forced labor laws here in the US and the way they're enforced, because it put the onus on the importer as opposed to a foreign producer to ensure that there was no forced labor in the supply chain. Flowing from that, in 2021, with the geopolitical situation that everyone pretty much is aware of between the US and China, the Uyghur Forced Labor Prevention Act was put into place. The 1-year anniversary was last week. And similarly, the UFLPA bans the import of goods made in whole or in part with forced labor, which is focused on labor that is coming out of the Xinjiang region of China or by certain designated entities and programs due to the use of forced labor in the Xinjiang region. And that's focused on the Uyghur population there, and the labor transfer and the forced labor that's associated with the Uyghur workers. So these are the two main statutes that are being forced here in the US. My next slide has a map of the Xinjiang region up in the northwest corner. As you can see, it's a very large region. I hear statistics of up to 85% of all cotton in China is grown in the Xinjiang region. There's other mining of materials there that go into batteries, that go into semiconductors, a lot of activity in that region. And the labor transfer programs that I talked about, the pairing program, the poverty alleviation program, is with the Uyghur workers are moving from the Xinjiang region all the way to other provinces in China. Section 1307 of the Tariff Act applies not only to a specific country, but is a worldwide ban. And I have a slide here which isn't particularly clear, but it shows a lot of what are called withhold release orders, WROs, and findings that have been issued against products mainly, sometimes regions with respect to import bans for those goods. China has the most, but certainly there are ones in Malaysia. There are ones in Malaysia with respect to certain agricultural products and rubber gloves, fishing vessels in the South Pacific. But as you can see, this is a worldwide effort by the US to root out forced labor within the supply chain. I'm going to talk a bit about the enforcement of the UFLPA and the WROs that have been issued by CBP. And CBP stands for US Customs and Border Protection, which is the primary agency in the US that deals with goods once they hit the border. Customs entries need to be filed and transmitted to CBP. And CBP enforces the regulations and laws of some 46, I believe, US government agencies. So the primary tools for enforcement are detentions and exclusions. So detentions happen when goods are coming in, they hit the port. CBP has reason to believe that there is forced labor associated with those imports. Customs will detain, CBP will detain those goods, and then the importer has to provide a very significant documentation to demonstrate that there is no forced labor in the supply chain. And I'll go through some of that documentation requirement. But once the detention submission is filed by an importer, if CBP is not satisfied, CBP will exclude those goods. And although I haven't seen a lot of seizures, they have the possibility of seizing goods if they believe that there is intent to circumvent the forced labor laws. So there's quite a bit at stake, and when you stop the goods at the border, there are real economic consequences. I have some of the deadlines here for consideration of those submissions. The importer has 30 days to provide those documents once goods are detained. Customs is at least giving one additional 30-day extension to that deadline in most cases. And we're finding that it takes quite some time for CBP to review the documentation once they have it. 90 to 120 days. I know I have some submissions now that are bumping up on that 120 days for the review. I'll also mention, just briefly, in addition to Section 1307 of the Tariff Act and the UFLPA, there are other laws out there that address forced labor in the supply chain. One is the Trafficking Victims Protections Act and its Reauthorization Acts, the TVPRA, which provides for both criminal and civil penalties for goods, for companies that actually are, quote, knowingly benefiting from the use of forced labor within their supply chain. One of the notable cases out there was filed last, I think it was last August, against one of the medical supply companies. There was the workers in Malaysia filed a case regarding the use of forced labor in Malaysia in the rubber glove industry. There's also the Department of Homeland Security its Homeland Security Investigations, HSI, is enforcing the TVPRA from a criminal standpoint. There haven't been cases yet that I've seen, but based on conversations with HSI, we're expecting some criminal cases to be issued in the near future. I have a list here of some of the industries that are targeted: cotton, apparel, automotive, solar, medical supplies, electronics, flooring, palm oil, tobacco, precious metals, seafood. These are just some of the examples. One thing that I'll mention here with respect, cotton, I think really was called out in the UFLPA as a key industry or key product where forced labor has been found, specifically in China, but there are other countries where cotton is an issue. So certainly the apparel industry is greatly impacted by these laws. The automotive industry, that's an industry that's been targeted by US Congress. Many of the auto companies have been approached and sent letters by the Senate Finance Committee for additional information and confirmations of regarding their procedures with respect to rooting out forced labor in their supply chains. Solar industry, certainly the silica, the mining of the ore that goes into the manufacture of the solar panels has been a big target, as well as many of these others here that I have listed. So let's talk about what happens when an importer receives a detention notice from CBP, whether it's with respect to the UFLPA or Section 1307 when there's a WRO in place. CBP requires all of these, and this is from their guidance document. This is a list of the documentation that CBP would require from an importer to demonstrate where the parts and components and raw materials came from. One thing I'll mention with respect to the UFLPA, there are kind of two parts to that. If an importer is able to demonstrate that there is no connection with the Xinjiang region of China, and certainly that there's no forced labor there, but it's really focused on no connection with the Xinjiang region or the Uyghur workers, then the scope of the UFLPA would not reach those shipments that are being detained. So the purpose of providing all of these documents is to demonstrate that none of those components and materials that go into the finished good originated in the Xinjiang region. You start with your bill of material, all the parts and components and the origins of those parts and components. And then you have to go back through the various tiers of the supply chain back to the raw materials. If you have apparel, you've got to go back to the cotton, and you've got to trace that cotton and other components all the way through the spinning and the ginning and the weaving and dyeing and cutting and the production processes associated with producing that finished apparel product. Similarly, for automotive parts and batteries and other similar goods, you've got to do the very same thing. So as you can imagine, this is quite onerous. We're finding that Customs is requiring pretty much 100% compliance with this requirement. And if there are tiers of the supply chain where you can't trace the raw materials through a lot number or through a unique identifying number, CBP often is rejecting those detention notices and moving on to the exclusion process. And when goods are excluded, they have to either be exported or destroyed. So they cannot enter the commerce of the US. Just a few comments on the enforcement details of the UFLPA. the CBP, excuse me, the CBP website has a trove of information, treasure trove of information, if you will, on some of the statistics with respect to the UFLPA and some of the other forced labor enforcement statutes. In fiscal year 2022, CBP targeted 3,600 entries at about $816 million in value. CBP is announcing that there are shipments being released under the UFLPA by providing those documents that I just mentioned. Those releases are few and far between, but as companies get to understand what's going on and what's going to be required, they are the submissions for the detention releases are becoming much more robust. And we're seeing in 2023 a significant increase in the UFLPA enforcement, as well as the WROs that are out there that are enforced by CBP. So what happens for a company when they're trying to institute a forced labor compliance program? What are some of the recommended compliance actions for a company? You know, I think in advising our clients, one of the first things to do is to take a look at your public-facing documents and your internal compliance documents. Look at your vendor codes of conduct, your human rights policies. Look at your vendor and buying agreements. It's really important, and Customs has mentions this in their guidance documents online, that U.S. importers that are purchasing goods made abroad really have to have very robust and very targeted provisions in their supply agreements to hold suppliers accountable, not at just the tier 1 level, but all the way back through the supply chain back to the raw materials. So those requirements for the finished goods producers need to cascade all the way back to the raw materials. This requires also review of procurement and supply chain and trade compliance policies to ensure that there is a program in place for this sort of tracking and tracing of the materials through the supply chain, and that they are effectively communicated internally as well as in the online statements for the company. The International Labor Organization in the U.S. has a website dedicated to forced labor with a list of goods that have been known to use forced labor, and it's something that's really good to check for companies that are importing into the U.S. to see if they have targeted products. We're also seeing and actually recommending in many cases the use of third-party consultants, many of which have been working with CBP to go through and actually identify potential risks within the supply chain and identify areas of high-risk exposure for forced labor. There are government lists. There's the UFLPA entity list, listing companies. It's not particularly robust, but just in the past couple of weeks, there have been 2 companies added to that UFLPA entity list as companies try to look at other lists that are out there from government agencies and resources. I'll just mention here, I think this is my last slide. There is quite a bit going on in this space. There are non-governmental organizations, NGOs, that are monitoring very closely what's going on. There's a university in the United Kingdom, the Sheffield Hallam University, where professors there are doing very extensive studies in industries where forced labor is present. And those studies have a lot of impact here in the U.S. Customs is monitoring those very closely. And as the Sheffield Hallam reports are issued, CBP is targeting and taking a look at those industries that have been examined. So with this, I'm going to hand it over to Peter Kirby to update us on what's going on in Canada.
Thank you, David. Good morning to all. I apologize for the huge amount of content in the slides, but I thought it best in the Canadian slides to put the content in, because in 10 minutes that's been allotted to me, I won't have time to go into the details. But what I'd like to bring to your attention is how fundamentally different the Canadian approach is to what we're used to seeing in terms of forced labor compliance efforts. What do I mean by that? Canada's Border Enforcement Agency, the CBSA, Canada Border Services Agency, their employees are overworked, understaffed, and they don't have the budget to engage in the kind of massive enforcement effort that you see in the United States. So the Canadian legislation takes a very different approach. The Canadian legislation essentially requires a number of entities, and I'll talk about the difference between an entity subject to the law and an entity that's called a reporting entity, but it requires corporations and others to file every day, on the 31st of May every year, a public report on what it's doing, the company is doing, to eliminate forced labor and child labor in the supply chain. So the approach taken by Canada is not so much border enforcement or putting the onus strictly on the importer, but what the Canadian legislation does is require companies to make public disclosures of what they have done and what they are doing to combat forced labor. What does that mean? That means essentially that instead of focusing on government resources to implement forced labor elimination policies, the Canadian government has conscripted all of the NGOs interested, shareholders of companies, journalists, and the Canadian population to look at these public reports and begin to decide where are they going to focus their efforts on basically a name and shame operation. Not only is it Canadian entities that have to do it, but in some cases it's the non-Canadian parent that also has to file a report. So we'll look at the importance of that, but the idea is don't think of this as one more customs compliance issue. It's a lot bigger than that. This implicates the board of directors of multinationals. And once the board of directors gets involved, all of a sudden you see changes throughout the corporate system. And we'll talk about that. What are the key dates to keep in mind? The legislation comes into force on January 1, 2022 to 2024, and the first annual report is due to be published. Each company has to publish their first annual report on May 31st, 2024, which is when you've got a document that requires the sign off of the board of directors. May 31st next year is not a long time away. So what does the Act do? There's basically four things that the Act does. One, it defines the entities that are required to file annual reports, and it then contains enforcement and penalty provisions. It holds company directors, officers, and agents personally responsible for deficiencies in the report, and it amends the Customs Tariff to prohibit the importation of goods. But that's we've always prohibited the importation of forced and child labor goods. This is simply a language change in the Customs Tariff. So if we turn to the next slide, who's affected? Two big issues in terms of who's affected. One is virtually every single government institution in Canada is going to be required. I'm sorry, I'm having trouble there with my view, and it's okay. Virtually every government institution is going to have to file their own public reports. Now, why is that important for other companies? It's important because in order for them to be able to file their reports, they're going to require a lot more information from their suppliers. So there's this cascading down requirement. In other words, for the government institutions to file the reports, they need to know details about the supply chain for goods that they buy, and they're going to be asking for those details in their contracts with the suppliers. So every company that is selling to the Canadian government is likely to be affected by the government's requirement that every government institution files an annual report. So keep that in mind when making contracts with the government. Then we talk about the other entities that are covered, and the covered entities in Canada. First, there's a definition of what is an entity subject to the Act. And then the second part of that is, within that group of entities subject to the Act, what are the entities that are required to report to the government? And the next slide, this is the first part of the test. Who are the entities that are covered by the Act? Any entity that's listed on a Canadian stock exchange. That's first and foremost. Then any entity that has a place of business in Canada, does business in Canada, or has assets in Canada that meet a certain threshold value. And you'll look at these threshold values and you'll see that they're not very high. At least $20 million in assets in Canada generates at least $40 million in revenue, or employs an average of at least 250 employees. Any two of those elements, and you become an entity that is subject to the law. Now, then the question is, okay, so if we are an entity subject to the law, do we have to file a report? And the entities that have to file the reports, these public reports, are entities that fit the definition of an entity, but produce, sell, or distribute goods in Canada, quote, or elsewhere, anywhere in the world. That imports goods into Canada that are produced outside of Canada, and this is where it reaches beyond Canada, controls an entity engaged in either A or B above. In other words, if a foreign company in the United States controls a Canadian company, and that Canadian company acts as an importer, if that entity is an entity within the definition, the US company, is obliged to file a report. And what has to be in this report, I won't go through all of the details, but what's important? The company has to report on the policies that it has on forced and child labor. That's easy. And we've all seen instances of policies that aren't really applied throughout the country, but it also has to report on what due diligence measures has it taken to make certain that the policies are enforced. The reports have to identify risks in the supply chain. In other words, the company has to think about where are the risks and then write them down and publish them. The report has to talk about what are the remediation measures that we've taken to eliminate forced labor and child labor. What have we actually done? And interestingly here, what have we done to remediate the impact of our remediation efforts on the incomes of those people affected by it. In other words, not simply to eliminate forced labor, but what measures are we taking to lessen the impact of our forced labor prohibition on the poorer workers that will now not be able to produce? It's something the company has to think about. Then the usual methods, what are the corporate training? It's not enough just to have a policy. What training is the company doing on its policies within the company? And most importantly, what measures are they taking to test the effectiveness of its policies? i.e., again, you can have your policy, you can do your training, but you also need to conduct the due diligence to make sure that the policy and the training are in fact having an impact on your supply chains. And again, don't forget, all of this is going to be public information. Finally, we get to the enforcement mechanism, and I won't spend much time on this, but there's a broad search and seizure power. We think, although it's not exactly certain, we think it's going to be the Canada Border Services Agency, the import agency, along with the RCMP, the Royal Canadian Mounted Police, which is the federal police agency, which will be investigating violations. And there's an offense of $250,000. Doesn't seem like much. There's no possibility of prison time. Wouldn't seem like much for a corporate offense, but don't forget, directors, officers, or agents, and agents would include the legal representatives of the company. They're all potentially personally liable for violations of the Act, and they can be convicted and penalized to the same amount, to $250,000, even if the company is not charged or penalized. There is a due diligence defense available, and that's important, i.e. you can demonstrate that you exercise reasonable diligence, due diligence, to avoid commission of the offense. And then we have the final prohibition on importation. I have to say, we have had this prohibition on importation on the statute books for a very long time, but the Canada Border Services Agency simply doesn't have the resources to effectively enforce a ban on forced labor. We don't have the resources that you see in the U.S. Customs Service to do the enforcement at the border. So the approach taken by Canada is, if we can't do that, what can we do? Well, we can require companies to publicly disclose, one, their supply chains and the measures that the company has taken and will continue to take to make sure the forced and child labor is eliminated from the supply chain. Why is that important? Because all of a sudden, it's not a border enforcement issue. It's not a customs compliance issue. This is an issue that the board of directors, and it is the board of directors that have to sign. It's the controlling body of the corporation, not a single director. The board itself has to sign off on these annual reports. So as those reports start making their way up the chain of command to the board of directors, all of a sudden, the company itself, there is a huge new focus on forced and child labor in the supply chains. It's an approach that is not seen in the other countries, to my knowledge. And it's an approach that is having an impact already in corporate behavior in respect of forced and child labor. In other words, it is now the responsibility of the board of directors to make sure that its annual reports, one, accurately state what they're doing, and two, are palatable to the host of different agencies, journalists, NGOs, etc., that are going to be going through these annual reports. So in other words, it's not simply a corporate to government reporting system, like say a tax return. The reports have to be given to the minister, but they're published immediately. So they can't contain confidential information. So then the question of how are they drafted so that the board of directors can actually sign off on them is a massive question within the corporations. And in my humble opinion, will likely have a much more dramatic impact on forced and child labor than all of the border enforcement measures put together. It will affect corporate decision making in a way that the lottery of prohibitions found in various countries will not have that impact. It also shows now, I think, the importance of what's happening in the US in terms of the Uyghur enforcement measures that are in place. Those measures are going to, the documents that that David mentioned are required. Those documents are now going to feed into the kind of reports that might have to be filed, that may have to be filed depending on whether the company is a reporting entity. There's a sort of harmonization of what is it that we need to do? What do we need to put into our report? Well, the US enforcement measures give you something of a roadmap to the kinds of things that you have to consider when you're drafting your annual report. I'm sorry, there's so much information in such a short time. I invite anybody. Okay, I'm out. Bye. Thank you.
Yeah, we should move on to Ricardo. Thanks for your presentation. Ricardo?
Thank you, Roy. Good morning to everyone. Good afternoon and good night also. Mexico environment is, we just heard Peter and David explain the Canadian and U.S. perspective of this issue. In Mexico, approach is more similar to the U.S. And how the U.S. is managing this forced labor restrictions. And recently, Mexico enacted and implemented the Ministry of Economy and the Ministry of Employment issued an agreement providing a mechanism to identify goods manufactured with forced labor practices, and whenever they find out and they finish that investigation, they restrict the import of that kind of goods. So this is more similar to a U.S. approach of a restriction order, or in Mexico is intending to implement what we call a blacklist. So this was published a couple of months ago in February 2023 and was enforced since May 18. And in precisely on that date, a guide explaining the procedure that the authorities will implement to verify the forced labor conditions was issued. So in a nutshell, what the labor authorities will do is to manage and trigger an investigating procedure in order to determine precisely if the production site located in a region of a specified country is producing goods using or under this forced labor or compulsory labor measures. Let me move on to the next slide. how is this investigation triggered? This investigation procedure may be triggered ex parte. This is a company, a Mexican entity, should be able to require the labor authorities to trigger this or launch this investigation, and also ex officio, the proper or the same authority is entitled to launch this investigation. And many of the we can see in the slides many of the required information that could be filed before the labor authority, which mainly would be, of course, the facts and description of the conditions that are presented in the production side, evidence that may be produced or that could be issued either by other countries. For example, David mentioned that the U.S. has already issued some orders relating forced labor. So the Mexican legislation or the Mexican rules provide that this is acceptable evidence in order to demonstrate that. So other country resolutions are going to be key and could constitute a serious background for goods that also could be imported into Mexico. Of course, labor inspection documents. We also heard these non-governmental organizations being quite fun and really monitoring this kind of important issues worldwide. So these documents and reports are also something that could be used as evidence. Press releases or information, of course, any photograph, video that could be showing the forced labor conditions will be admitted. Also, the information of the goods that are manufactured in that site, for example, the tariff code, the production site information, and who is the importer of record of those goods into Mexico. Also, if the labor authority launches ex officio this investigation, it would also require information to foreign authorities, such as, of course, the affected country and other interest countries will be also required to be or to produce any informations. And as also part of this investigation, the authority will require information to the importer of record, such as invoices, purchase orders, transport documents as bill of lading, inventory records, among others. So this is more or less what the labor authority will try to analyze and in order to conduct properly and determine if there is a forced labor condition in a specific production site in a country, and the timing or the timeline that they have. They have 180 days to solve or to issue a decision of the investigation process. This legal term could be extended for another 180 days in case it is necessary, only for one time. There's only one time extension. So this could take over a year, this type of investigation. And what will be the outcome if the investigation gets to an outcome where they determine there are forced labor conditions involved in manufacturing this type of products? Well, they are included in a blacklist that will be implemented by the Mexican government and by the Mexican customs authorities, identifying, of course, the tariff code, the description of the product, and the manufacturing site, country, and region, in order to prohibit its importation into Mexico. And once a good is included in this blacklist, there's a procedure to review the products included in the list, of course, with the intention to analyze if they should be removed or not. But the issue here is that this procedure it takes also 6 months. So at least if once a good is included in this blacklist, the restriction for its importation would last no less than 6 months. So and could be extended for over a year. So this is quite important for the supply chain, and it could be another disrupting issue for the supply chain. And just to mention before I conclude, the other measures that have been taken by other countries, for example, U.S. has been really active on this matter, could and surely will be taken into consideration by the Mexican Labor Authority when conducting their investigation process. So I think a good key and a good key element and a good prevent compliance issue, besides the one that are mentioned in the slide and that David explained also as a corporate governance in order to prevent this kind of restrictions, could be to take into consideration what other countries have already been investigated and restricted. That surely will impact also Mexico, and we can start preparing ourselves with this type of defense filing, as we call it, in order to identify, of course, internal and manual policies in the supply agreements, try to include specific clauses and liability for suppliers, or to establish obligations to them in order to review and be in compliance with these forced labor restrictions. And collaborating with foreign inspection and civil international organization will be also a key issue for this. I think more or less this is in a nutshell what is happening in Mexico. Of course, up to date, there has not been any product included in the list since it's really recent, the enactment or implementation of these restrictions.
Thank you, Ricardo.
Thank you, Roy.
And now we'll turn to Bert on the EU, and Bert's going to have to talk fast.
Thank you, Roy, but I will do. I'll try to summarize the EU proposal in a few bullet points. We have more slides, like every one of our speakers, we have more slides which we can, I think, distribute among the participants in this seminar, but I'll try to be short here. The EU proposal is at this point just a proposal. It's a proposal raised by the Commission. There's no agreement yet on the proposal. The legislative process is ongoing with discussions at EU Parliament level and between the EU member states on what will ultimately be the final legal act. But everyone expects that this will come. The proposal was presented in September 2022, and there is no formal deadline, but as EU elections are coming up in 2024, the aim is to find an agreement early 2024 on this topic. So what is specific on the EU proposal? Well, it's specific that it covers all. It covers all products coming from all regions, and it targets all companies, whether they're small or large companies or multinational companies. All companies involved or operating in or with the EU are falling within the scope of this product. It's not simply an import ban, it's more than that. It covers also the export of items produced in the EU with forced labor. It simply targets everything which is put on the market in the EU. What is different as other similar systems across the EU is the fact that there is quite a high threshold of evidence. Under the EU proposal, it's up to the competent authorities, and the competent authorities will be authorities which are designated by each specific member state. The enforcement agencies, we will not have one, we will have 27, as we have 27 member states. And the threshold for violating or for establishing a violation of the legislation is that there needs to be proof of forced labor, and not only suspicion like in other legislation, but there needs to be actual proof of forced labor, and it's up to the competent authorities to provide that proof. In practice, we know that this is quite a high threshold in some cases where you speak of state-sponsored or state-organized forced labor. We know that it's very difficult to obtain such evidence. Another weakness, or at least identified weakness of the program, is the fact that it does not include any remediation for the workers, which are ultimately the victim of forced labor. This is a gap which is identified. We know from a recent report of the EU Commission, from the EU Parliament, that member states are working to improve that, to include that in the proposal, but at this point it's not yet sure that this will finally be included. It's up to the negotiations between the member states and within EU Parliament. Another issue that is identified is that it covers all products and even all components of products. Businesses are afraid that a minor component used in a machine, for example, for which there is a suspicion that this minor component is produced with forced labor, might result in months long of investigation and proof and counter proof of any alleged forced labor. So that is also a weakness which is identified in the program. And then there is the ultimate weakness we have in all EU legislation, is the fact that competences are divided between the member states and the Commission, and the Commission will issue guidelines in order to harmonize enforcement and application of the legislation in all 27 member states. They will establish a database which will identify clear risks, areas of concern, products of concerns. They will assist the member states and the member state organizations, the member state authorities, to do their work in a harmonized way, so that an import in Bulgaria would face the same consequences as an import into Belgium or the Netherlands. But we all know that is often more theory than practice, and that is a continuous battle for the EU institutions to harmonize enforcement in practice. So that is, and I think I can be very short in order to allow everyone to raise some questions, if anything. But I think that's the main thing. The EU proposal targets all products from all regions, and all companies fall within the scope. It's more than import; it's import, export, putting on the market in the EU, and it's the EU member states that will ultimately enforce this piece of legislation.
Thank you, Bert. Do we have some questions? And the questions can be either from audience or they could be from one speaker to another speaker.
This is David Stepp. I've got a quick question for Bert. And again, I don't want to take away from other attendees who might have questions, but can you just call out the countries in Europe, in the EU, that have forced labor laws that are either in effect or about to go into effect?
This is an EU proposal, David. Obviously, it adds to some existing national legislation, which already exists in some member states. The ultimate idea is obviously to bring that national legislation in harmonization with this EU proposal. But countries like Germany, for example, already have a national legislation which targets forced labor in this respect.
This is Roy. I have two questions, one for Ricardo, first for Ricardo and second for David. Ricardo, when the blacklisting is done, is there any indication that specific suppliers will be named? That's my question for Ricardo. And then for David, my question is, David, could you let us know what's going on with the $800 de minimis exception? Because that bangs right into forced labor.
Yes, Roy, thank you. Let me answer quickly your question. That's the intention. Precisely, the intention is to identify the production sites and, of course, the companies that are involved on that, and identify precisely the manufacturing good in order to restrict the import. That's the measure it's going to be implemented. So in order to either avoid or establish an economic impact in order to avoid those forced labor measures, and also to evidence who is performing them.
And Roy, with respect to the 800 de minimis, that's the so-called Section 301 entries, lower value entries that are allowed expedited entry into the U.S., often at the behest of or facilitated by the e-commerce companies. There's a huge push on Capitol Hill and in the U.S. Congress to re-examine that $800 de minimis rule, whether by lowering the amount, the threshold amount, to a lower value, or actually excluding goods from particular countries such as China. This exception is being used a great deal in the apparel industry and obviously other e-commerce platforms. It's going to be, I think, an interesting and perhaps a bloody battle on Capitol Hill as with this issue.
Thank you, David. Any other questions? If not, then I think we will close the webinar. Thanks, everyone.
Thank you, everyone. It's a pleasure.
Thank you, everyone.
Thanks.
Thank you very much.